Judicial review is an important element in the relationship between the executive and judiciary under the doctrine of separation of power.
In this video presentation, the extent of the rules of locus standi in limiting the availability of judicial review will be analyzed and critically evaluated.
So, what is judicial review? Judicial review of administrative action is designed to keep those public bodies and persons with delegated powers within the powers conferred to them by Parliament, which is the doctrine of intra vires.
Hence, action for judicial review of administrative action employ the concept of intra vires, ultra vires, and the rules of natural justice to ensure that the executive acts within the law.
Judicial review is concerned with the process by which decisions are made, not with the merits of the decisions itself.
According to Ministry of Justice statistics, 11,200 applications of judicial review were made in the year of 2011 alone. More than two-thirds related to immigration and asylum cases. Most judicial reviews are not based on a challenge to the merits of a government decision, but the fairness and lawfulness of the procedures followed. Before we go on, it is important to define locus standi. Locus standi basically means the right of a party to appear and be heard before a court. In another word, without a locus standi, no case will be heard in court. It is one of the aids to limit judicial review and will be discussed throughout this video. Section 31 Sub 3 of the Supreme Court Act 1981 provides that no application for judicial review shall be made unless the applicant has a sufficient interest in the matter to which the application relates. Over the years, the classification of sufficient interest criterion has been vague and unclear. The case of R and Inland Revenue Commissioners ex parte National Federation of Self-Employed and Small Businesses formed the seminal starting point of the court's jurisprudence in this area. As is well known, a pressure group challenged the legality of a tax amnesty arrangement entered into between the Inland Revenue and the casual print workers. Provided that the print workers registered for tax purposes, no investigation would be made as to tax laws in certain previous years. Although the challenge ultimately failed, Lord Diplock famously said that in another word of Lord Diplock, everyone should be able to bring their case to a court for a hearing. These statements indicate that in some circumstances, the law of standing has merged with the merits of the case. This means that if the claimant can show that the body has acted unlawfully, the court will review the case even though the claimant may only have a remote connection to this case. This broadens the test for standing in non-human rights judicial review claims. In R.N. Secretary of State for Foreign and Commonwealth Affairs ex parte World Development Movement, a highly respected pressure group successfully challenged a government decision to commit very large amount of money to an economically flawed overseas development scheme. Rose L.J. observed that in the absence of a challenge by the pressure group, it was hard to see who else would question the decision, and cited the importance of vindicating the rule of law as a key argument in favor of acknowledging standing in such circumstances. As a conclusion, without any doubt, this particular area of administrative law has caused controversy over the years. The court needs to find the balance between Dicey's postulate of rule of law and giving people the rights to bring their cases to trial.
Next, it will be discussed on the sufficient interest test. The test of sufficient interest was provided in R and Inland Revenue Commissioners ex parte National Federation of Self-Employed and Small Businesses. The House of Lords approach was as follows. The question of whether their standing should be examined in two stages. At the first instance, standing should be considered when leave to apply is sought. At that stage, the court is concerned, according to Lord Scarman, to ensure that it prevents abuse by busybodies, cranks, and other mischief makers. If leave is granted, the court may, at the second stage, when the merits of the case are known, revise its original decision and decide that, after all, the applicants do not have sufficient interest. Next, the effects of sufficient interest test will be discussed. According to Adam Perry and Farad Ahmed, courts grant public interest standing partly based on features of the claimant, They claim that the features of a claimant are relevant insofar that they constitute or evidence civic virtue. They also claim that a claimant is normally entitled to public interest standing only if, by bringing the claimant's application, the claimant is acting as a virtuous citizen characteristically. However, how do the court determine whether a claimant is entitled to public interest standing? How to determine the civic virtue? Is it based on the 10 factors listed as below? These factors are: the claimant has a genuine concern for the matter to which the claimant's application relates. The claimant is not a mischief maker, meddler, troublemaker, or busybody. The claimant is not acting out of ill will or ill motive or for an improper purpose. The claimant is public spirited. The claimant has the right history and experience. The claimant is responsible. The claimant is well informed, has the right expertise, has the right credentials, and holds a position of respect. However, according to some scholars, this may be problematic. Peter Kane argues it would not be right to turn away a litigant because of inadequacy of competence or resources. Timothy Endicott worries that factors such as respect and prominence are thinly veiled proxies for power and prestige, leading to standing in favor of the famous and also against the underprivileged. Endicott also criticizes the factors concerned with a litigant's motivation. A court can, he says, grant a litigant leave to seek judicial review without deciding that they are acting in the public interest. It just has to be in the public interest to hear that. Hence, is the convention right to have a fair trial safeguarded? It is noted that the European Courts of Human Rights have clarified that the right to take administrative actions is also included in the right to have a fair trial. Hence, the availability of judicial review may be restricted by the locus standi principle as postulated by the characterization of the civic virtue required in the sufficient standing test. Besides that, the discretionary power conferred to the courts may be problematic, as the judges decide on the question of whether sufficient interest exists. The judges have the discretion on applying acceptable differentiation principle to decide on sufficient interest or locus standi. It is highlighted in the case of R and Inland Revenue Commissioners ex parte National Federation of Self-Employed and Small Businesses, in which the House of Lords held that the NFSSB did not have locus standi to challenge the revenue's decision with regard to another group of taxpayers, even though NFSSB was attempting to challenge the revenue's grant of tax amnesty to Fleet Street casual workers on the grounds that it was illegal. The issue is, does it contradict to the second postulate of Dicey regarding rule of law, which is everyone should be equal before law? However, in R and Secretary of State for the Environment ex parte Rose Theatre Trust Company Limited, Skyman Justice cited a number of propositions which he deduced from the IRC case. An important guideline is the question of whether sufficient interest exists is not purely a matter within the discretion of the court. In other words, the courts do not have absolute discretion. Therefore, the locus standi or sufficient interest test may limit availability of judicial review. This is due to two reasons. First, Adam Perry and Farah Ahmed argue that the court grants standing based on the civic virtues. Second, judges have discretionary power in determining whether a claimant is entitled to public interest standing to a certain extent. These two reasons may cause the availability of judicial review to be restricted and cause the doctrine of rule of law postulated by Dicey, which is equality before law, impaired. However, it is argued that this impairment is to a certain extent only, as judges do not have absolute discretion.
In the discussion on standing, we must consider the effects of the Human Rights Act of 1998. The Human Rights Act came into effect in the year 2000. and has had a great impact on the operation of judicial review in the United Kingdom. The Act imposes upon courts a legal duty to comply with rights contained in the European Convention of Human Rights, and has effectively redefined the traditionally understood concept of judicial review. This reception of European law into English law was masked by the cloak of bringing rights home. However, as we will see, the ways in which the Act has been implemented raises many doubts as to whether it falls short of this goal. In this section, we will look at how the Act has limited the exercise of judicial review. Here, it is important to consider the relevant provisions contained in the Act. Section 6 of the Human Rights Act provides that a public authority includes a court or a tribunal, and that proceedings against a judicial act may be brought by way of appeal or by application for judicial review. Section 7, subsection 3 of the Act provides that an individual may make an application to the courts if and only if he or she is or would be a victim of an unlawful act. A person claiming that the public authority has acted or proposes to act in a way that is made unlawful by Section 1, subsection 3 may bring proceedings against the authority or may rely on the convention right concerned any legal proceedings. Section 7, subsection 7 of the Act specifically states that only a victim found under Article 34 of the Convention has sufficient interest to make a claim against public authorities for an unlawful act. This displaces the ordinary interpretation of the sufficient interest test. In comparison, the victim test is far more restrictive than the sufficient interest test and other methods of determining standing for judicial review. A victim is someone whose rights have been directly or indirectly affected by an act alleged to be unlawful. However, it is evidenced through case law that the meaning of the word victim has not been given a consistent interpretation. In Dudgeon in UK, the applicant, a homosexual man, was considered by the European Court of Human Rights to have victim status. This is because he belonged to the class of victims to have been targeted by laws criminalizing homosexual acts in force at the time in Northern Ireland. Although no criminal proceedings have been brought under those laws for years, it was held that the applicant held victim status because he had to live in constant fear that he might be prosecuted for homosexual acts at some stage. In contrast, the case of Lead in UK showed the Commission's reluctance to interpret victim as to include all persons who might be affected by the disputed decision. The injury was deemed too remote. This elasticity in the meaning of the word victim leads one to speculate whether certain factors legitimate a broader rule of standing. From the perspective of public interest, the victim test has also been proven to be inadequate as a means of gauging whether one has standing. The European Convention of Human Rights does not allow for actual popular risk, that is, to bring an action based on abstract arguments that a particular decision or legislation would tend to contravene the Convention. Applicants must be personally affected except in very limited cases like that of Donnelly in UK. In particular, it may prove difficult to discern between cases in which the applicant is considered a potential victim of a legal act or an application seeking an abstract examination of the law. The case of Norris and Ireland, which holds similar case facts to that of Dudgeon in UK, considered that the mere existence of criminal laws imputing homosexual acts amounted to the interference with the right to private life. Further, the victim test prescribed under Section 7 generally precludes public interest challenges made by groups or organizations taking action on behalf of their members. This necessitates the willingness of the victim to bring proceedings, and it is not uncommon for victims to want to withdraw their case for various reasons, as was the case in Tyra and UK. This greatly limits the availability of judicial review and may, in certain cases, hinder the vindication of rights. In India, where this has become an increasingly prevalent problem in the weakest links of society, the Indian Supreme Court has actually allowed interest groups to commence social action litigation in respect of human rights violations where the victims of various reasons are unable to do so. Local courts, seeming to have realized this, have over the years loosened their grip on third-party intervention. Article 36 governs this. Hence, we conclude that the victim test introduced by the Human Rights Act places an unconscionable limitation upon judicial review and stands in the way of its effective operation.
On the other hand, there are also arguments that state that locus standi does not limit the availability of judicial review. However, it makes sure that a claimant who is entitled to public interest standing must bring the right sorts of case with the right sort of person, have the right motive, the right background, the right knowledge, and right reputation. Locus standi exists not merely to vindicate individual rights, but to vindicate public rights, and therefore permit members of the public to agitate such rights. Any member of the public having a sufficient interest can maintain an action for judicial redress of public injury arising from breach of public duty or violation or of some provision of the Constitution or the law, and seek enforcement of such public duty and observance of such constitutional or legal provision. Of course, it must be ensured that the person who comes forward is acting bona fide and not for personal gain or private profit out of political motivation or other oblique consideration. The justification of locus standi lies in the strong need to limit the challenges to administrative decision-making to genuine cases of grievance. Furthermore, it exists also to avoid unnecessary interference in the administrative process by those whose objectives are not authentic. A claimant must bring the right sort of case to be entitled public interest standing. It is believed that every citizen has a stake in the public good, also known as the public interest, and the person who can bring the claim must also be the right sort of person, as stated above. The fact that the claimant has to have a genuine concern in the matter, that the claimant is not a busybody, and that the claimant is not acting out of ill will is important to the motive appropriate to civic virtue as mentioned earlier. Moreover, claimants who are public-spirited and has suitable experience and history contributes to fulfill civic virtue too. Here are some cases. In ex parte Rees-Mogg, standing was granted to a member of the House of Lords to challenge the UK's ratification of the Maastricht Treaty because of his sincere concern for the constitutional issues. In Walton, the claimant was entitled to standing because of his genuine concern about the effect of the impugned decision on the environment. Conversely, the courts have been clear that litigants will normally not be entitled to public interest standing unless they are motivated by public good. Lord Justice Sadly said in Dixon that even a claimant with an arguable case would be denied standing if the claimant acted from an ill motive. In Fickens, Lord Justice Dyson said that it would normally be an abuse of process to grant a litigant standing if the claimant is acting out of ill will or for some other improper purpose. Someone who wants to interfere in other people's private affair is a busybody and a meddler and will be denied standing, a point made both in Walton and much earlier in National Federation. Furthermore, as mentioned earlier regarding the point on civic virtue, the virtuous citizen makes a better advocate for the public good than the selfish, indifferent, or inept citizen, other things being equal. The virtuous citizen fits Justice Hawthorne's admiring description in Greenpeace of a litigant capable of mounting a relevant, well-argued, and effective challenge. Hence, to illustrate the virtuous citizen concept, an example can be given. Person A fulfills the characteristic of virtuous citizen, whereas person B does not. Both of them filed application for judicial review, assuming that both of them are making the same type of application for public benefit in the same locality. A is granted the leave to apply for judicial review, whereas B is not granted. This is actually justified because A is likely to effectively represent the public interest for that locality. Furthermore, this is also to prevent the opening of floodgates to a vast amount of individuals and organizations to apply for judicial review. Besides that, it is crucial to maintain the efficiency of judicial review. Hence, the court is more willing to grant standing to those virtuous citizens when there are two or more applications for judicial review for the same ground. In conclusion, although some people are not granted the locus standi to apply for judicial review, it may be argued that the rationale of the court is to make sure that the person with genuine concern and right motive to apply for judicial review, preventing floodgates and ensuring the efficiency of judicial review are the supporting factors too. it can be argued that it does not limit the availability of judicial review, but it just ensures the availability of judicial review is not abused.
Indeed, there are justifications for and against the doctrine of locus standi in limiting the availability of judicial review. However, it is imperative that we take into account other factors that play an equal, if not greater part in the limitation of judicial review functions. To start off, let us dive into the broad concept of justiciability. There are certain subject matters in which the courts show reluctance in reviewing, such as those concerning the exercise of prerogative power, issues of national security, and also matters of high policy, all of which are non-justiciable. Now, let us zoom into matters of public policy, which is one of the matters located outside the scope of judicial review. Essentially, courts will decline exercising a supervisory function over such issues because matters of public policy come under the domain of the executive instead of the judiciary. Any purported attempt to place control over this decision would most certainly defy the doctrine of separation of powers because boundaries will be crossed.
In the case of Nottinghamshire County Council and Secretary of State for the Environment, Lord Scarman ruled that unless and until a statute provides otherwise, or it is established that the Secretary of State has abused his power, these are matters of political judgment for him and for the House of Commons. They are not for the judges or your Lordship's House in its judicial capacity.
Next, there is a variety of statutory means utilized to limit judicial review as well. The general requirement that applications for judicial review are brought within 3 months of the challenge decision under the Civil Procedure Rules. Clauses which are intended to prevent any challenge. Clauses which limit review to a specific time period to avoid delay. And also conclusive evidence clauses. Firstly, I will be talking about time limits. As mentioned above, there are statutes that provide that judicial review can only be exercised within 3 months. The Supreme Court Act 1981 also stated that shorter time periods may be stated in statute and will have to be complied with. An example would be the case of Smith and East Allo Rural District Council. A challenge to the validity of a compulsory purchase order was limited by statute to a 6-week period following the date of confirmation of the order. Failure to do so would eventually result in the failure for it to be questioned in legal proceedings. The plaintiff in this case sought to challenge the order only 6 years later on the grounds that bad faith, which could impugn the order's validity despite obviously exceeding the time frame established by statute. However, the House of Lords ruled that the words of the statute were clear and rejected the view by a majority as there is no exclusion to its application. Secondly, ouster clauses. So as to enable protection for the administrative process, Parliament may attempt to exclude judicial review of certain decisions by stripping the courts of their supervisory judicial function. This can be troublesome for the courts as they are expected to, on one hand, uphold Parliament's will, but at the same time ensure that public bodies comply with the rule of law. In the seminal case of ouster clauses, Annis Milling and Foreign Compensation Commission, even though there was an ouster clause that states that the decision of the Commission would be final, the House of Lords decision held that it can only be final if the decision was valid. Thirdly, conclusive evidence clauses. Parliament may effectively oust the jurisdiction of the courts by inserting a clause into statute which provides that a subordinate piece of legislation shall have effect as if enacted in this Act, or that confirmation of an order by a designated minister shall be conclusive evidence that the requirements of this Act has been complied with, and that the order has been duly made and is within the powers of this Act. Even though such clauses were strongly criticized by the Committee of Ministers' Powers, they remain relevant and have been effective in ousting judicial review. A case to illustrate this would be RN Registrar of Companies ex parte Central Bank of India. Here, a clause in the Companies Act 1985 successfully ousted the jurisdiction of the courts. Ultimately, it can be concluded that yes, locus standi does affect the availability of judicial review, but it would be unreasonable to take it as a stand-alone element. It is therefore important for authorities to consider the significance of other contributing factors as well when searching for possible reforms to control the situation. And it is with the combination of all these factors that judicial review is limited holistically.
So, does the law of standing in need of a reform? From the perspective of the executive, judicial review should be limited by further restriction on the law of standing. In the consultation paper called Judicial Review Proposal for Further Reform September 2013, the government of the UK proposed to restrict the law of standing in judicial review, and it was, in fact, criticised by many commentators, including the members of the judiciary. This led the government to drop the idea of changing the law, but it is worth considering the debate that occurred around the proposal, as it shows the importance of liberal rules of standing in ensuring access to the courts. In R, on the application of Plantagenet Alliance and Secretary of State for Justice, a case regarding the granting of standing to the Plantagenet Alliance to challenge the burial of the remains of Richard III in Leicester Cathedral. This case was criticized by the Ministry of Justice. Here, the court held that the claimants, who are the descendants of Richard III, had a genuine interest in pursuing the claim as the burial place of a monarch was a matter of some public importance. The concern is that narrowing the rules of standing would prevent legitimate claims from reaching the courts. Consequently, this would mean that, contrary to the rule, government action that was unlawful but where no individual was directly affected could not be challenged in the courts. In order to answer the question critically, it is important to note that this questions and underestimates the importance of judicial review in ensuring the government decisions are taken properly and following court procedure. As we know, the executive is elected constitutionally, so it has to follow the law as laid down by Parliament, and if it does not do this, then it should be made accountable through the courts. Ultimately, the government dropped the proposal to narrow the law on standing, although the various procedural changes in the Criminal Justice and Courts Act 2015 to the cost rule and restriction on legal aids, which means it is likely to make it more difficult for judicial review claims to be brought by interest groups.
The constitutional role of judicial review is to uphold the system of checks and balances inherent in our constitutional settlement. The requirement of standing remains requisite in an action for judicial review, whether under the sufficient interest test or the Human Rights Act.
To impose such stringent requirements would place an insuperable barrier for individuals to bring an action for judicial review.
From the presentation, it is argued that the locus standi test limited availability of the judicial review. It is evidenced in the discretionary power conferred to the judges in granting standing for a judicial review.
Besides that, the narrow scope of the sufficient interest test for the victim test will restrict the availability of judicial review too. However, there are arguments for the contrary.
Additional contributing factors such as time limits, exclusion clauses, and non-justiciability are to be considered as well. All members of our society have an interest in the proper administration of executive power, and it is for this reason that access to judicial review should not be restricted to those directly affected by the matter at